Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello and welcome to our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is John Roberti, and today's topic is, did someone open the door? Private challenges to consummated mergers. Many folks in the antitrust world are familiar with the merger clearance process, where a filing or a notification is made to an authority. The authority has a period of time to decide whether or not to review the merger. If the authority decides not to review the merger or not to take action, the parties are clear to close the merger, and they go on. But there's another path to looking at mergers, and that is a private path. In the United States, private parties have the right to go and to challenge a merger, even one that has been consummated and finished, if they can prove that the merger had anti-competitive effects. This is an area that recently has had a number of very interesting developments. And today we have one of the leading lawyers who has been sort of at the front of this new trend towards private challenges to mergers. And we're going to talk to him and learn a little bit more about this. My co-host today is Anora Wang. Hi, Anora.
Hi, John.
Anora, what are we doing today?
Well, today we're going to discuss private litigation over a consummated merger. As you explained, that's when a private party coming to the court challenging a merger that's already closed. And
why is this important?
Well, this is important. This is actually inherently interesting because two important elements meet here. One, as you explained, private parties might complain to the government about a contemplated merger of competitors, but less likely to spend money and time in court to challenge that. And then two, consummate mergers, meaning the parties already merged, so it's harder to challenge. As a common saying goes, you can't really unscramble a scrambled egg.
Unscramble the egg, unring the bell. Who is our guest today?
Well, we are fortunate enough to have Jack Martin, who is a partner at the law firm Hunton Andrews Kurth, with more than 25 years of experience in civil and criminal antitrust litigation, including his previous experience at the FTC and DOJ as a trial lawyer. And then specifically on the civil antitrust side, Jack has the rare experience of challenging or defending several consummated mergers, including several very interesting ones that we're going to discuss a little more.
All right, Laura, let's bring in our guest. Jack Martin, welcome to the program.
Thank you. It's great to be here, John and Anora.
Thanks for joining us. And then, Jack, I would jump in with something that's actually surprising when I first learned about it, which is the statute of limitations. Is it true that there in contrast to damages suit, meaning suit for money, that there is not really a limitation on when a private can bring a suit for an injunction, meaning seeking an action that the court orders the parties to do or not to do?
Yes, that's right. There is no statute of limitations for an injunction action. The way the Clayton Act is set up, there's one statute that authorizes damage suits, and very clearly there's a 4-year statute of limitations for that. There is a second statute that authorizes injunctions, and there is no mention of a statute of limitations as to that injunction provision.
Meaning, theoretically, I can challenge a merger that's many years ago.
Yeah, I mean, I don't know of any case where anyone's ever done it, so I would say theoretically, yes. There is a Fourth Circuit case that it's a little bit tough to tease out exactly what's going on, but it sounds like the Fourth Circuit is borrowing the 4-year statute limitations from the damage statute for the injunction statute. So that authority is out there. In the government context, the government has challenged a merger 20 years after the fact in the DuPont case.
Yeah, that definitely was surprising when I first learned about that, because just put yourself in the shoes of the defendant, right? Like, you have been merged for many years, I guess. You can argue that, there has been a lot of money spent, there has been a lot of integration and new investment and operations, and then it's just hard when you're not seeking just money, you're seeking, like, you're ordering them to be separated again, or taking some other actions. Is that one of the difficulties that I guess that's inherent in a private challenge to a consummated merger?
Certainly. I mean, and the way the Supreme Court has looked at the issue, there's a case called California Stores, and the Supreme Court has very clearly said that a private party may bring a post-consummation action seeking divestiture. And the Supreme Court says, and this is really just borrowing the statutory language, that principles of equity apply and govern whether or not a court should grant the injunction. So, clearly, the more time goes by, the more likely it is that there's going to be, to use your metaphor, a greater scrambling of the eggs. But the point is that there is no clear cutoff in that there is no statute of limitations. So the answer to when is it too late would be it's too late when equity says it's too late.
Right. So another thing is that, the law allows that, right? And then the design of the law allows that because there's a role that's envisioned about, bring up to be brought about by private parties. And that's important, right? I think that's one of the arguments that DOJ has made in one of the current matters that you have. Is that right?
Yeah, yes, that's right. So there was an argument before the Fourth Circuit in late May or early June, and the government filed an amicus brief, and they actually appeared in the oral argument, and they said their position is that private enforcement is important to the statutory scheme, and B, that there is no inherent bar to a private consummated merger challenge. They did not take a position on, where the ultimate equities lay in that case. But one thing that they did say that was very interesting to the equity analysis is they said they want private parties to cooperate with them in their investigations. So they do not want to see a private party punished for taking the very reasonable action of not doing anything while they wait to see what the government is going to do and cooperate with the government and, not take on the burden of an expense of their own case. If the government enforcement or non-enforcement doesn't go the way the private party wants, the DOJ wants there to be no, punishment for that delay.
Right. So I think we have already gone into some details of that case. And for listeners who are not familiar, this is a case involving door makers. And then this is about a challenge of a merger that's, I guess, close 5 years ago, before actually being challenged, right? And then this draws a contrast because most, if any, private challenges to consummated mergers happen within a year of closing. So, of course, this is not as extreme as the example that Jack pointed for before, 20 years after that's DuPont case, right, in 1960s. So 4 years.
That's the government, but yes.
Right. So still 4 years, that's quite significant. And then this case, significant for many other reasons. One other reason is that the parties challenging a deal is asking for divestiture, which was proved, right, by the trial court?
Yeah, the district court ordered a divestiture.
Yeah, so the development so far is really unprecedented, and many of us are watching closely. And I think well, this is unprecedented. Also, there's many levels into not just this case, but in the area of private parties challenging, because we see difficulties in these challenges being made. Another thing is that not all private parties have standing, right? Not all parties can just come to court that I don't think that's a good deal, I'm going to challenge. You have to have a, what do we call, an antitrust injury and standing, right, Jack?
Yes, that's right. It's important to note, though, if you dig into the case law, you will see the term antitrust injury all over the place. And anyone who's ever done a Sherman Act or any antitrust damages case is familiar with the term antitrust injury. What's important for this purpose is that very same term is used under two different statutes. So the damage statute, Section 4 of the Clayton Act, gives rise to the question of antitrust injury. And there you've got to show that there has been past injury to your business or property. The injunction provision, Section 16 of the Clayton Act, is future-looking. And it says that if you have, I believe the term is threatened loss or damage, that is threatened in the future, you can bring an injunction suit. And the term antitrust injury gets applied to that as well, but it's very clear that they're different, because one is forward-looking and one is past-looking. And in both statutory schemes, of course, you've got to show not just injury in fact, but you have to show injury of a type that the antitrust laws are designed to prevent. And so you've got to show some sort of harm to competition. And, specifically in the merger scenario, the law is going to take a hard look at that when it's a competitor as opposed to a customer making the challenge.
Jack, this is John. I wonder if I could take a step back. You've done a number of these. When does it make sense for a client to say, hey, I really want to look at taking this burden on privately? What are some of the factors that you've seen that have motivated clients to take this rather extraordinary step?
Yeah, that's a great question, and it's similar to just about any major litigation. You do have a fee shifting provision, so that if a client wins, the client will get their attorney's fees, but there's never any guarantee. And of the big cases I've been involved in, antitrust are probably some of the most expensive ones. So first of all, there's financial means. I think what it is likely to come down to for a client is just how important is this? In antitrust cases, you often hear the term bet the company. Imagine the scenario where there is, a meritorious case. That means you have now become a customer of someone who, basically controls access to a resource that you need. And if that resource is important enough to you, it may be worth the money. I think another situation or another factor that needs to be considered, in some cases, your client may be both a competitor as well as a customer, and that really creates some difficult incentives upstream, in the sense that the supplier has every reason to want to cut off the downstream purchaser if they're also competing with them downstream. So it's going to come down really to how important of an issue is it for your company that you're willing to take on the significant burden and expense that this kind of litigation can bring. But in some scenarios, it has been worth it to some clients.
And yeah, I was just going to say, every case is different, right? It's all embedded in the facts. And then if litigant is actually serving dual roles, right? I'm not just a competitor on this level, but on another level, I'm a supplier or a customer, then the analysis definitely changes.
Absolutely.
Right?
I mean, if the supplier is only a supplier, then what they have an incentive to do maybe is raise price, and that's bad. But if the supplier is both a supplier and a competitor, it might be more profitable for them to just stop selling the product at all. And so if you need that for your business, you might be able to tolerate a higher price, but if it's an absolutely essential input and you can't get it at all, then it's a threat to survival.
Chuck, you and I both, in fact, we were together at the FTC many years ago. And I think my experience, and probably yours as well, is that when the government looks at a merger, they are much, much more concerned about what the customers or suppliers, upstream or downstream, are saying about the potential transaction. And once in a while you'll hear, get the sense that the government says, well, look, if the competitor is complaining, it must be a good merger, right? Because if it's bad for the competitor, that must mean it's the competitor is going to have to work harder. I'm wondering if the private litigation option isn't one that maybe is a little more attractive or picks up some of the slack on where a competitor is concerned. As you said, it can be a supplier and competitor at the same time, but where the competitor is the one that has a greater level of concern.
Yeah. Well, so yes, I did hear that when I was at the government, and I agree completely with you on the customer versus competitor analysis. The cases that I have done in this area have both been on behalf of customers. So I have not really ever faced a situation when I had a pure competitor challenging a merger. When you're in this two-level situation, when you're wearing both hats, that makes the issue a little more subtle. But I think that customers generally are the ones with the credibility for the reason that you say. So I think in that dual situation, it's generally to your advantage to emphasize the customer aspect.
Yeah. As we're speaking of the government's analysis, I think this is actually a good timing to turn to a point that's really interesting. In the doormaker case, to the extent that you can talk about it, Jack, the government really, the DOJ really looked at it already, right? And then they gave a pass of the deal, and then, quote unquote, right? And then what do a private litigant argue to remedy that fact that, or just to preemptively to say, even though the government doesn't really challenge it, we have a case here. So what should a court make of it, or, if any, of that fact?
A couple answers to that. One answer is to just listen to what the Department of Justice said, because they, as I said, they filed a brief in that case and they appeared at the argument, and their position was pretty clear that their decision not to challenge was not dispositive, nor was it a factor to be weighed. That they have any number of reasons not to challenge a merger, resource issues, and other factors that make it such that a non-challenge decision, it's like a government inaction in any case. All it means is that the government did not choose to file a challenge. It doesn't mean that they quote approved it, and you see that word all over the place. I even saw it in a Supreme Court opinion the other day. You see the word approve with reference to a government non-prosecution decision, and that is most definitely not what happens under Hart-Scott-Rodino. What happens is you have to wait, and the government either has to challenge or not challenge.
Yeah, you often see the word the government cleared this merger, and actually they never really cleared it. They just didn't challenge it. Interesting, Jack, because we had the opportunity to speak with some folks who worked on a big merger, Sprint T-Mobile, where the government had gone in one direction. The U.S. government had gone in one direction and come up with a resolution for the merger, short of blocking it. A group of states challenged it, and in reading the opinion there, I thought the judge found it to be very influential that the government had decided, that the U.S. government had decided that the merger could go through with some remedies. Interesting that you were able, or that parties have been able to convince courts in consummated mergers that even though the DOJ took no action, there's still something here.
Yeah, and that's interesting that you mentioned that. I mean, I think. Legally, my view is as I just said, that it's a non-prosecution that has no weight. But anyone who's been out there doing this as long as you and I have, we've run into all kinds of different judges, and the Department of Justice is such a big and important litigant that just about every judge out there has a view of the Department of Justice. So as a practical matter, I think there are judges. Whether overtly or subconsciously or whatever, may weigh that one way or the other. For every judge that would defer to the Department of Justice, you have a judge who would go the other way. But as a practical litigation matter, I think that factor is definitely going to be out there.
Yeah. And not just judges, right? Also, sometimes you have a jury, which is even more interesting. And then I think that's the situation that you have with your ongoing matter. So I think there are, a jury trial presents complexity, complications that, to any trial. But for antitrust like this, there is certainly pros and cons, for you as arguing for your client. So what are they? And then is there really some actually advantages of having a jury in such a complex matter? Yes.
So, so first of all, if all you're looking for is an injunction, you can't have a jury. So that makes it easy. But in one of the cases I've handled, there was both a damages and an injunction claim. And in that case, there was a jury. And to the best of my knowledge, it's the only time a jury has ever been called upon to decide if a merger is legal or not.
Yeah, that's the first in 40 years, as if my research is correct.
Yeah.
Yeah.
Well, so I think, I think surprisingly, it is a really jury-friendly issue. Merger law can be technical and complex, and you get the economists, but what it comes down to is something everybody understands. It's having a choice. And, I teach a class on antitrust at UVA, and every year I introduce the class before we learn any antitrust law. I ask the students to come into class the following week and tell me about a situation in their life when they were dealing with a monopolist and they didn't have a choice to go somewhere else. And invariably, every student comes in and they've got they're excited, even though it might have been upsetting. They want to talk about some life experience dealing with a monopolist. So I think it is very much a juror-friendly issue to present this question of because of a given merger, the people who wanted to buy the product downstream did not have a choice.
Yeah, Jack, it's a really good point. And isn't that the big challenge of advocacy, is to take something that's hard and make it simple?
Absolutely. That's happens in every case, and particularly every jury case. And I think antitrust generally, and merger law more specifically, lends itself to that because it's despite all the economics, despite all the technical stuff, it's life. It's consumers who sometimes have a choice and sometimes don't.
And I think some of our younger lawyers, as they learn how to do merger law, it is complicated, and they sometimes we get stuck in the jargon and thinking that something that's really complex, explaining something that's really complex in a complicated way makes us look smart, feel smart. But I think the challenge is actually the other way, to take something that's really complicated and explain it to somebody who doesn't do what we do. And that could be, and by the way, that's not just a jury, right? Because you may have very, very smart federal judges and state judges as well, who just, haven't taken economics since they were sophomores in college.
Yeah. One other great example of this that also comes up in teaching is market definition. Despite all the economics and the critical loss analysis and all these tests, the Supreme Court definition of market definition standards is basically reasonably interchangeable. And I always tell the students, pick your product and then, ask the question, is X product reasonably interchangeable with Y? And it comes down to sort of nothing more complicated or less complicated than human behavior. And to make that simple can be a challenge, but you also can draw on, people's history as a consumer.
Yeah. And another area, just to divert a little bit, another area that's also constantly thought about, but I guess more prominent in a private litigation over a consummated merger context is that the competitive effects is to some extent already tested, right? And then I guess that's an inherent tension between challenging it, I guess, too early or too late. You constantly hear when you actually challenge a merger that, you're predicting the market, the competitive effect. And now you have a merger, maybe a year or 4 years after it's closed. There is some of that effect being seen. And then how do you deal with that? And then is it more difficult or hard to deal with that in such a context?
Yeah. Well, so you're absolutely right that you are likely to have an effect. And if I could just peel off for a minute to the government scenario, when John and I were at the FTC, was when the FTC brought the Evanston Hospital case, and that was a challenge to a consummated merger of hospitals that followed years of difficulty by the government in defining markets. So the theory was, we can just, rather than have to go in and define a market and say how big the merging entity got, we can see if there were effects after the merger, and that theory was successful. In the private scenario, it really presents a tension because you're going to have more evidence of what the merger's effects were, obviously, the longer you wait. But the longer you wait, the more the equitable factor of time, to the extent it counts, is going to count against you. So there is frequently a tension.
Jack, and I guess the other thing, now, again, going back to the Sprint T-Mobile case, which again is front of mind for us because we just, there's a program that we've put out on that. The judge lamented in the very front of the opinion how difficult it is to predict the outcomes, and basically said, well, I guess I have to do my best, but I'm really not happy about having to predict things. So that does create a real challenge if you're trying to predict it. At the same time, if you wait too long, you lose on the equitable factor, and you also may have the privilege of representing a bankrupt entity.
Yeah, but both are an issue. I mean, I'm going to need to reread that opinion. To that problem, I would say, well, there's a lot of difficult legal problems out there, and that's what you got to do. The Supreme Court's term in the Section 7 of the Clayton Act is incipiency, right? The whole point of merger law is you don't want to make everybody go around and be the victims of monopoly and sue for damages. You want to stop it before it happens. So the Section 7 of the Clayton Act, the merger law, exists for the reason that you want to stop anti-competitive situations in their incipiency. So, we just got to roll up our sleeves and listen to the experts and do the analysis and do our best when the law says it's about future, stopping problems before they happen.
Yeah.
Jack, before we shift gears, one last question from me, which is, any final thoughts on what you think the role of private challenges to consummated mergers is going to be going forward? Do you think we'll see more of it? Do you think that the recent cases maybe have opened a new door to antitrust enforcement?
Yeah, I don't know. I think the best comment that I can make, if you look at the antitrust jurisprudence, and I'm not talking just about mergers now, I'm talking about antitrust as a whole, you see the term private attorney general all over the place. And so there is no doubt that the congressional scheme, going all the way back to the Clayton Act in 1914, is that Congress wanted government enforcement to benefit from the supplemental resources of private attorneys general. So, I certainly think that there will be cases when a consumer, I don't mean like a person, but a business that consumes a product is going to find a need to serve as a private attorney general. I don't know if it's a coincidence or not, but I've for whatever reason had two of these cases in the last year. I can't say that my experience is typical, but I again would say that the private attorney general concept is a very important one.
Well, we'll watch this space, and we will continue to watch this. I think it's an interesting issue. Jack, if you wouldn't mind, I'd like to shift gears a little bit. Maybe give our listeners a chance to get to know you a little bit better. Tell us something interesting about yourself that we wouldn't know if we only knew you professionally.
Yeah, sure. So I'm doing this interview in my office in Richmond, Virginia. I keep an office in D.C. As well, but I live here in Richmond. I'm looking out onto a Class 3 rapid on the James River, and when I'm not working as a lawyer, I work as a whitewater raft guide. So tomorrow I will be taking some customers down the James River, and we'll be enjoying some whitewater and some nice weather. And it's just a great way to do a whole lot of things, to get some exercise, to have fun, to share something I love with other people. And so I have two jobs. I'm a lawyer and a whitewater raft guide.
Wow, I thought all lawyers are risk averse.
Well, I let's just say we got a good waiver.
And I bet you we're a life preserver as well. How did you get into the whitewater rafting business? I'm really a passionate outdoor person, and that's been my thing. I love to go hiking and skiing and that kind of thing. And for years, I sort of said to myself, well, you need to go to these far off places. And, I would take trips to the Alps and so forth. And I love that. But one day I just said, wait a minute. We live in this city where you have this great outdoor activity available right here. You don't have to buy a plane ticket. You don't even have to drive a car all the time. Sometimes I just ride my bike down to the river. And so it was sort of a combination of my love for the outdoors and kind of an interest in staying local and taking advantage of what I have right here. Jack, what advice would you give to younger lawyers who want to get into the role of litigating and trying antitrust cases?
Yeah, I would say two things. I would say number one is trust yourself. And I also would say number two is use the power of the law. And here's what I mean by those. Trust yourself. So we've been talking about consummated mergers, and they're kind of an unusual thing. And, that's why you guys were kind enough to invite me on this program. The legal analysis to, support the view that you can do a private consummated merger challenge, it's not that sophisticated. You just take a look at the statute, and it's pretty clear that that's what it says. And so it's like a whole lot of areas of law that I've seen. Sometimes the answer to the problem is just a very simple hit the books and do the research answer. And I think a lot of time the people best at that are the ones straight out of law school. And so I would say to the younger lawyers, trust yourself, do the analysis, figure out what you think the answer is, and don't sell yourself short just because you may lack experience and may lack a number of years. Yeah. So on the second point, the power of the law, I have found, both in the antitrust context as well as I do a fair amount of indigent criminal defense, and I have seen just how powerful a tool the law can be. And whether it is a client who has the resources to pay for big antitrust litigation, or whether it's a criminal defendant who doesn't have any money at all, the law is a very powerful tool to make a difference in companies or individuals' lives. And if young law students can find some area where they want to make a difference, I think that the power of the law is an awesome tool that they can have at their disposal.
I remember when I was at my commencement from law school many years ago, the dean of the law school said just that you're leaving this school now with a very powerful tool and a great deal of responsibility. So really good advice. Jack, we're going to go to our final segment that we call the Curious Hat.
And now it's time for the Curious Hat.
In my left hand, I have a set of cards that have questions on them. We are not going to use a hat today because we are not all together. But Jack, I'd like you to pick a number between 1 and 25, and I will ask you the question that corresponds with that number.
Okay. I'll pick 12.
12. Now, it's a good strategy to go right in the middle because you would think we wouldn't give you the hardest questions right in the middle, but let's see how we did. Okay, question number 12. What is the best thing about your generation?
Best thing about my generation? Well, I'm going to first start by telling you I think I'm the last baby boomer born. There's different definitions of the baby boom, but the best one I've seen is between the end of World War II and the Kennedy assassination. And I fit right just barely in there. So I'm a baby boomer. So everybody's going to say, okay, boomer, when they want to mock us.
I was just going to say that. and I was wondering if you would be offended by that.
No, I am not offended. What's great about my generation is, I think we were pretty lucky. I think we came along at a good time. I mean, that's the whole point of the baby boom. And I guess what I would like to think is that those of us at the tail end of it have done a pretty good job of making things at making things good for the next generation. Not perfect, but as I sit here and look at my kids, both of whom are home now because of COVID, I hope we've done a good job in preparing them.
Well, you are a baby boomer. Jack Martin, thank you so much for joining us today. Great program. And we will see you next time on Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.